Yes, sir. Yes, sir.
Good evening and a very warm welcome to you to the training session hosted by Advocates Association Bengaluru. Sir, ತಾವು ಎರಡ ಸಿಸ್ಟಮ್
ಇಲ್ಲ ಇಲ್ಲ
ಲಾಗಿನ್
ಅದಕ್ಕೆ
ಆಗಿ
ಅದಕ್ಕೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಎಕೋ ಆಗ್ತಾ ಇದೆ. Good evening and a very warm welcome to all of you for the training session hosted by Advocates Association Bengaluru in collaboration with Advocates Academy Bengaluru. We have a very prominent and acclaimed resource person today with us, Honorable R Venkata Sudarshan, sir, is a former district and sessions judge. Sir was also the member of district commission, consumer commission at Shimoga. Sir, for sir, this is not the first time he is on this forum. He has hosted and he has been a resource person here several times for Advocates Association as well as Academy. In fact, once I remember last week we were discussing, sir had come all the way from Shumaga to address the young advocates who were preparing for civil judges examination. Sir, it's an honor and privilege to have you on this forum, sir. On behalf of Advocates Academy, Advocates Association, on behalf of the participants and my personal behalf, sir, a very warm welcome to you, sir. Over to you.
Thank you very much, Mr. Trivikram, sir. Thank you. Good evening to everybody. ಎಲ್ಲರಿಗೂ ಶುಭ ಸಂಜೆ. At the outset, I express my sincere thanks to the President and Office Bearers of the Advocates Association Bangalore and Advocates Academy Bangalore, and also the organizers of this program, and more particularly to Mr. Trivikram, sir. It's a great pleasure for me to be on this platform for the simple reason that it is in Bangalore that I started my practice as an advocate in the year 1978 to 1980 as a junior of Sri late Y. Adinarayan Rao and T. Radhakrishna. So therefore, I always feel it pleasure to speak on this platform, which is my home bar. I thank all the organizers concerned for having provided me this opportunity to be on this platform and share my few thoughts on the important subject of law, that is Bharatiya Sakshya Adhiniyam, that is Indian Evidence Act. My target is only the young advocates and the advocates who are preparing for aspirants to the post of judicial officers, civil judges. I am not an expert. I am still learning, and I am in the process of learning. So whatever the best opportunity that has been given to me, I would like to make use of it to the best of my ability and knowledge and place before you the few thoughts of mine so far as the new branch of law is concerned. Indian Evidence Act or Bharatiya Sakshya Adhiniyam is, though a bad act, is very simple, running into only a few pages. In my opinion, and I hope the considered opinion of other senior advocates also, if I am not mistaken, that every section in this act or in this Sanhita is a world by itself. It is very difficult to understand. Any amount of readings, repeated readings, will give a new insight into the subject and it opens up. However, this subject is so important, not only to the advocates practicing both on civil and criminal side, but also for the judicial officers presiding over both civil and criminal courts. Because the Evidence Act is common for both, except the law relating to confession. All other provisions are applicable for both civil as well as criminal cases, in my opinion. Therefore, according to me, this subject is of great importance for every advocate and also for every person who wants to become a judicial officer, and a judge who is presiding, is already presiding over the courts. The Indian Evidence Act of 1872 was there since 1st of July 2024, which is replaced by Bharatiya Sakshya Adhiniyam. The reason for its replacement is very simple and not very difficult to understand. The Indian Evidence Act as such was a beautiful legislation, a wonderful enactment which meets all the situations and all the eventualities. And it was in force in this country for over a period of 153 years and about more than 7.5 decades after independence. But because of the development in the field of science and technology, and more particularly in the field of electronics, the electronic records and digitalization, there was a need for revisiting the old Evidence Act in order to meet the changed situations. Digitalization has now become a part of man's existence. Even for payment of a small purchase with a vegetable vendor, a street hawker, he will have a QR code with him and he wants us to make payment through the online only. This is the situation in which we are now prevailing. We are now living. And therefore, one can imagine the magnitude and importance of the digitalization and also the electronic record. And its importance or credibility or the evaluation evaluation to be made in the courts at the time of appreciation of evidence. So therefore, according to me, there was a need for change. And therefore, the Indian Evidence Act has been replaced with the present law, that is Bharatiya Sakshya Adhiniyam. The Indian Evidence Act 1872 had 167 sections spread over 11 chapters. And the Bharatiya Sakshya Adhiniyam has 12 chapters with 170 sections. The important sections which have been amended or which have been introduced rather have been amended or introduced keeping in mind the development in the field of electronics, that is electronic record and digitalization. Now, before going to the important provisions in the Evidence Act, it may not be possible. In fact, it is the opinion of all. I don't think Mr. Trivikram sir will disagree with me that Evidence Act or a Bharatiya Sakshya Adhiniyam is considered to be a subject which is hard nut to crack. It is very difficult subject to understand and also analyze and comprehend. One reading or even two readings may not be sufficient. A repeated readings makes us to have more and more insight into the subject, and it enhances our knowledge. That is the magnitude of this subject. Now we are all aware that there are two types of laws. One is the substantive law, another one is the procedural law. Substantive laws are the statutory laws passed by the legislature. Whereas the procedural laws comprises the rules and processes which any court follow for hearing and determining the case. To put it in other words, substantive law is that branch of law which determines the rights, duties, and liabilities of the persons involved in a transaction. It does not provide the mechanism or the machinery through which one can protect, preserve, or enforce his right, or insist upon the obligator to perform his duties and liabilities. For that, the procedural law is there. So the procedural law is a mechanism or a machinery through which the rights, duties, and liabilities which are found in the substantive law could be enforced, protected, and preserved. Mere knowledge of a substantive law is not sufficient, alone is not sufficient, or having full knowledge of the procedural law alone is not sufficient. An advocate is expected to have a thorough knowledge of both the substantive law as well as the procedural law. They are the two faces of the same coin. To quote some of the laws which are substantive laws, or for example, take for example Indian Contract Act, Transfer of Property Act, Specific Relief Act, Registration Act, Stamp Act, Sale of Goods Act, Partnership Act, Limitation Act, etc. And also take for example the penal law, Indian Penal Code or Bharatiya Sanhita. These are all some of the enactments which can be quoted for stating that they are substantial laws. Take for example Transfer of Property Act. Transfer of Property Act only says what do you mean by a transfer of property under this particular act, how it is different from a testamentary disposition, what do you mean by sales, how a sale can be affected, what are the duties, rights and liabilities of buyers and sellers, etc., etc. Like that, it may be a case of a sale or a mortgage or a lease or
Can
a
I
gift or
disturb
an
you for
exchange.
one moment?
Please,
Sir,
sir.
one moment, can I disturb you, sir?
Please, sir.
ಕೆಲವರು ಕನ್ನಡದಲ್ಲೂ ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಸೊ ದಯವಿಟ್ಟು ಮೈ ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್ ದಟ್ ಮಿಕ್ಸ್ಚರ್ ಅಲ್ಲಿ ಬರ್ಲಿ ಅಂತ.
ಓಕೆ ಸರ್, ಓಕೆ.
ಸಾರಿ ಸರ್.
ಕಾನೂನಲ್ಲಿ ಎರಡು ಭಾಗ ಇದೆ. ಒಂದು ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಲಾ, ಅದು ಕನ್ನಡದಲ್ಲಿ ನನಗೆ ಹೇಳಕ್ ಬರೋಲ್ಲ. ಇನ್ನೊಂದು ಪ್ರೊಸೀಜರ್ ಅಲ್ಲ. ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಲಾನಲ್ಲಿ ಯಾವುದೇ ಒಂದು ವ್ಯವಹರಣೆಯಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಪಾರ್ಟಿಗಳ ಹಕ್ಕು, ಬಾಧ್ಯತೆಗಳು ಮತ್ತು ಕರ್ತವ್ಯಗಳನ್ನ ಮಾತ್ರ ಹೇಳುತ್ತೆ. ಉದಾಹರಣೆಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಅಂತ ನಾವು ತಗೊಂಡ್ರೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಆ ಆಕ್ಟ್ ನಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಏನು, ಅದಕ್ಕೂ ಮತ್ತು ಟೆಸ್ಟಮೆಂಟರಿ ಡಿಸ್ಪೋಸೇಷನ್ ಅಂದ್ರೆ ಬಿಲ್, ಇದಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಏನು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಮತ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಕ್ರಯ, ಸೇಲ್ಸ್, ಮಾರ್ಗೇಜ್, ಭೋಗ್ಯ, ಗಿಫ್ಟ್, ದಾನ ಅಥವಾ ಲೀಸ್, ಬಾಡಿಗೆ ಕೊಡೋದು ಅಥವಾ ಎಕ್ಸ್ಚೇಂಜು, ಇಂತಹ ಪ್ರಕ್ರಿಯೆಗಳಲ್ಲಿ ಆಯಾಯ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಇರ್ತಕ್ಕಂತಹ ಪಕ್ಷಕಾರರ ಹಕ್ಕು, ಕರ್ತವ್ಯ, ಬಾಧ್ಯತೆಗಳ ಬಗ್ಗೆ ಮಾತ್ರ ಹೇಳುತ್ತೆ. ಆದರೆ ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಹಕ್ಕು ಬಾಧಿತವಾದಾಗ ಅಥವಾ ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಹಕ್ಕಿಗೆ ತೊಂದರೆ ಕೊಟ್ಟಾಗ ಯಾವ ರೀತಿ ಕ್ರಮವನ್ನು ಜರುಗಿಸಬೇಕು, ಅವನ ಹಕ್ಕನ್ನು ಯಾವ ರೀತಿ ರಕ್ಷಣೆ ಮಾಡ್ಕೋಬೇಕು, ಯಾವ ರೀತಿ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು, ಅಥವಾ ಯಾವ ರೀತಿ ಬೇರೆಯವರು ಅವನ ಹಕ್ಕನ್ನ ಇಂಟರ್ಫಿಯರ್ ಆಗದೆ ನೋಡ್ಕೊಳ್ಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಪ್ರೊಸೀಜರಲ್ ಲಾನೇ ಮುಖ್ಯ. ಸೊ ಪ್ರೊಸೀಜರಲ್ ಲಾ ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಫಾರ್ ಸಿವಿಲ್ ಕೇಸಸ್, criminal procedure code for criminal cases. Indian Penal Code or BNS does not say that you don't commit an offense. It only says that if you commit such and such an offense, you are punishable with so much of imprisonment. But how to book a person who is committing an offense into, how to bring a person who has committed an offense into books? What is the procedure to be followed? How the investigation will have to be conducted, how inquiry will have to be conducted, how trial will have to be conducted, which court will have to conduct the trial, how the trial will have to be conducted, what is the stages of a trial. All those things are mentioned in Bharatiya Sakshya Adhiniyam or CRPC. So there are two types of laws. One is substantive law, another one is procedural law. So far as Evidence Act is concerned, it is said that it is of the Evidence Act we find that it is a combination of both. So it is said that Evidence Act is an adjective law. Having understood the two different branches, two different categories in law, that is substantive law and procedural law, now we will move on to the Bharatiya Sakshya Adhiniyam. Regarding the statement of objects, I have already said, but there is I am reading out from the very report of the report itself. The Indian Evidence Act 1872 was enacted in the year 1872 with a view to consolidate the law relating to evidence on which court could come to the conclusion about the facts of the case and then pronounce judgment thereupon, and it came into force on 1st September 1872. That is about 154 years ago. The experience of 7 decades of Indian democracy calls for a comprehensive review of our criminal laws, including the Indian Evidence Act of 1872, and adopt them in accordance with the contemporary needs and aspirations of the people. The law of evidence, not being a substantive or a procedural law, falls in the category of an adjective law that defines the pleadings and methodology by which the substantive or procedural laws are operationalized. The existing law does not address the technical advancement undergone in the country during the last few decades. Accordingly, the bill has been introduced and law has been enacted. The proposed legislation inter alia provides for, it enhances the definition of the word evidence, and it also seeks to expand the scope of secondary evidence to include copies made from original and mechanical process, copies made and compared with the original, and its counterparts are documents against the parties who did not execute them, oral accounts of the contents of the document given by some person who has himself seen it, and giving matching hash value of original record, etc., etc. So these are the objectives with which the Bharatiya Sakshya Sanhita has come into force by replacing the good old Indian Evidence Act. Now coming to the important provisions of the Bharatiya Sakshya Adhiniyam, as I have already told that there are about 170 sections. It may not be possible, or it is humanly impossible to cover all the sections within a short span of 2 hours or 3 hours. Therefore, I would like to go into the details of first the definition clause. They are very important for the simple reason that unless we know the definition clause of especially so important words, terms, and phrases properly, it may not be easy for us to understand the rest of the provisions of the Bharatiya Sakshya Sanhita. Therefore, the definitions of some of the words and phrases which are used in the definition clause are necessarily to be looked into and understood. What do you mean by evidence? Evidence is the usual means of proving, it is the usual means of proving or disproving a fact under a trial or inquiry. It does not include arguments. It tends to convince the court of the truth or otherwise of the matter. That is, when an evidence is let in by both the parties before the court, while appreciating the evidence, will remove the chaff from the grain, remove the grain from the chaff and appreciate the evidence and arrive at the actual truth in the case. So there are two things, facta probanda and facta probentia. Facta probanda refers to the material facts that must be proved to establish legal claim or defense, while facta probentia refers to the evidence of facts used to prove those material facts. To put it in a very simple manner, whatever the pleadings that a party takes up, either in the plaint or the written statement, that can be considered as facta probanda, and whatever the evidence that has to be let in order to prove the burden placed on the respective parties, that can be considered as a facta probentia. In one of the judgments of the Madras High Court, P. Chidambaram versus R.S. Rajakannappa, it is held that there is a distinction between facta probanda, the facts required to be proved, that is material facts, and facta probentia, that is facts used to material facts. Only the relevant facts are required to be proved. The same as the judgment of the Honorable High Court reported in 1980. So, facta probanda is required to be supported by fact. What do we mean by this? Mere pleading is not sufficient without corresponding evidence, or any amount of evidence without pleading is also not acceptable. This is the fundamental rules, meaning thereby When a party pleads something, he takes burden upon himself to prove when the other party denies it. So if he doesn't place evidence before the court to prove that particular fact, mere pleading is not sufficient unless there is a sufficient evidence placed before the court. Similarly, any amount of evidence that is written without there being a pleading also cannot be accepted. So the facta probanda, facta probentia are the two faces of the same coin. Both are supportive to each other. Now, what does the BSA Act deals with? BSA Act mainly deals with what are facts in issue, what are relevant facts, what are admissible, what may be proved, what facts may not be proved, what kind of evidence may be given of a fact, what kind of evidence to be given in order to prove a particular fact, and who has to produce such evidence, how it is to be given. All these things are discussed in detail in the Bharatiya Sakshya Adhiniyam. What are the principal rules of evidence? The principal rules of evidence are, number one, best evidence to be produced. That is, whatever the best evidence that I have, in order to support my case, I must produce it. I cannot withhold any evidence. I cannot suppress any evidence. I must produce all the best evidence that I have. If I do not produce any best evidence that I have, mere argument or mere pleading cannot be accepted. So the court may at times draw adverse inference against me if I do not produce the best evidence that is available with me. Second principle is the hearsay evidence is not admissible. Hearsay evidence means it is not a direct evidence. It is an evidence which a party gives of having heard the same through somebody else. So such an evidence is not admissible. There are some exceptions to it that we will see later. Evidence may be given of facts in issue and relevant facts. Here, I would like to draw the attention to Section 4 of the BSA and which was equivalent to Section 5 of the Indian Evidence Act. This particular section says, evidence may be given in respect of a suit or other proceedings. Evidence may be given in a suit or other proceedings only in respect of the matters which are fact in issue, or matters which have been declared as relevant, facts which have been declared as relevant in this chapter and no others. This is a command, meaning thereby the parties before the court are expected to lead evidence, either oral or documentary, whatever it is, they are expected to lead evidence only in respect of the fact and issue or the facts which have been declared as relevant under Chapter 2 of the BSA, that is from Section 4 to Section 50 of the Bharatiya Sakshya Adhiniyam. Andre, ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಕ್ಷಕಾರರು ತಮ್ಮ ಮೇಲೆ ಇರತಕ್ಕಂತಹ ಒಂದು ಹೊಣೆ, ಸಾಬೀತು ಮಾಡತಕ್ಕಂತಹ ಹೊಣೆಯನ್ನ ಅವರು ಸಾಕ್ಷ್ಯ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇಡಬೇಕಾದ್ರೆ ಅವ್ರು ಇಡ್ತಕ್ಕಂತಹ ಸಾಕ್ಷಿ ಹೇಗಿರ್ಬೇಕು ಅಂತಂದ್ರೆ ಆ ಕೇಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟಿರ್ತಕ್ಕಂತಹ ಫ್ಯಾಕ್ಟ್ ಇನ್ ಇಶ್ಯೂಗೆ ಮಾತ್ರ ಸಂಬಂಧಪಟ್ಟಿರಬೇಕು, ಅಥವಾ ಸೆಕ್ಷನ್ 4ರಿಂದ 50ರವರೆಗೂ ಹೇಳಿರ್ತಕ್ಕಂತಹ ರೆಲೆವೆನ್ಸಿ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಚಾಪ್ಟರ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿರ್ತಾರೆ ಆ ರೆಲೆವೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಆಗಿರ್ಬೇಕೆ ಹೊರತು ಬೇರೆ ಯಾವುದು ಅಲ್ಲ, ನೋ ಅದರ್ಸ್. So that is the meaning of saying evidence may be given of facts in issue and relevant facts. All facts except the contents of the document. Evidence may be given of facts in issue and relevant facts only, no others. We will discuss when we come to Section 5. All facts except the contents of the document may be proved by oral evidence. That is also found in Section 60 of the Evidence Act and equivalent provision in BSA. Facts judicially noticeable need not be proved. Facts admitted need not be proved. Oral evidence must be direct. So these are the broad principles. These are the broad principles of which are to be kept in mind while leading evidence in a given case, in a particular case. If you read the Indian Evidence Act and also BSA in a juxtaposition, you will find that certain provisions have been deleted. Certain provisions which were found in the Indian Evidence Act have been deleted. If you read BSA, which are they? Section 3, Clause J, where the definition of the word India was found in Evidence Act has been deleted. Section 82, presumption as to document admissible in England without proof of seal or signature, deleted. Section 88, presumption as to telegraphic messages, deleted. Section 113, proof of secession of territory, deleted. Section 166, power of jury or assessors to put questions, deleted. These are the provisions which have been deleted. If you read BSA and Evidence Act, you will come to know about it. Now, coming to the definition part. In between, if you read Evidence Act and also the BSA, Section 3 of the Indian Evidence Act deals with definitions. Section 4 of the Indian Evidence Act deals with law relating to presumptions. In BSA, Section 2 and 3 have been taken together. Section 3 and 4 of Indian Evidence Act have been taken together and they are incorporated in Section 2 itself. This is one important change which you have got to note. So all the words which are defined in Section 3 of the Indian Evidence Act and also in 4 of the Indian Evidence Act, you find it in Section 2 of the Bharatiya Sakshya Adhiniyam itself. In addition to that, there are some more definitions included or some more amendments or modifications made. Now, I am not going by the definitions in the order in which the Indian Evidence, Bharatiya Sakshya Adhiniyam is showing. I am going in an order which can be easily understandable according to me. First, I will take what do you mean by a fact, what do you mean by a fact and issue, and what is a relevant fact. Then we will take what is the meaning of evidence, what is the meaning of document, and what is the meaning of proved, not proved, disproved, and what is the law relating to presumptions. Section 2, Clause F defines the word fact as fact means and includes anything, state of thing, or relation of thing capable of being perceived by the senses. 2, any mental condition of which any person is conscious. According to me, this definition is very, very important for understanding the entire provisions of the Bharatiya Sakshya Adhiniyam in Indian Evidence Act, because law of evidence revolves around the facts of the case only. Whichever provision you take in the law of evidence or in the BSA, there is a mention of the word fact. So unless we know the definition of the word fact properly, it may not be possible for us to understand the remaining sections in the BSA in its proper perspective. Fact means and includes. Whenever the definition part says means and includes, it means and includes only that much and nothing else. Only that much means only what is stated in that particular section or subsection and nothing more than that. This principle you can find in the judgment of the Honorable Supreme Court reported in AIR 2019, Supreme Court, page 4411. Means and includes is a legislative phrase. And yes, 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 yes. Trivikram sir? Trivikram sir?
I'm sorry, sir. I'm his colleague. Some disturbance now. You may continue my notes.
Okay. Means and includes is a legislative phrase used in legal definitions to establish an exhaustive
My lords, you have to unmute yourself, my lords.
Is it okay?
Yes, please, my lords.
Is it okay?
Yes, my lords.
Yes. So when they say that fact means and includes, that means whatever that is stated in that particular definition, clause F of section 2 is only the meaning that can be given to the word fact and nothing else. What does it say? There are two clauses in this section. One is anything. Anything means anything, or state of things, that is the state in which the things are placed, or relation of things, that is relation of one with the other, which can be perceived by the senses. What do you mean by this? ಮನುಷ್ಯನಿಗೆ 5 ಪಂಚೇಂದ್ರಿಯಗಳಿದೆ. ಕಣ್ಣು, ಮೂಗು, ಬಾಯಿ, the ನಾಲಿಗೆ, ಕಿವಿ. These are all the 5 organs which are sensible organs. So these organs, whatever that can be perceived, whatever that can be comprehended, whatever that can be understood by these 5 organs, such things, such state of things, such relation of things are called facts. Look at the example. Illustration number 1, 2, and 3 are the examples of the first category, that is anything, state of things, or relation of things capable of being perceived by the senses. What are those illustrations? Number 1, in a certain place is a fact. Certain objects arranged in a certain place in a certain order is a fact which relates to anything, any state of thing, or any relation of thing which can be perceived by the senses because you can see them. That a person heard or saw something is a fact. If I have seen something personally, and if I tell it to you, that becomes a fact. If I have heard something directly, that becomes a fact. So whatever that I have heard, whatever that I have seen, that becomes a fact. That a person said certain words. When I say some words about something, or about some person, or about some object, that becomes a fact. Then coming to the second one. Any mental condition of which any person is conscious. Any mental condition of which any person is conscious. Go to the fourth illustration. That a person holds a certain opinion, because first clause 1 can be considered as physical facts, because they can be seen, they can be touched, they can be felt, because they're all perceived by senses. But second one is what is working in the mind of a person, that cannot be seen, that cannot be touched, that cannot be felt. So they're all mental facts. That a person holds a certain opinion. What opinion X has got towards Y, it is only in the mind of X and nobody else. So that is a mental condition. Or has certain intention. With what intention I did a particular act, whether that intention was bona fide or mala fide, is a fact which is within the mind of the person who has that intention and not anybody else. And acts in good faith or bad faith. If I do some job in a good faith, and if something goes wrong, I may not be held liable. But if I do something with a bad faith, with an intention to do something wrong, then I am answerable. Fraudulently. A fraud is also a mind game. A person does something in order to deceive a person. So there is an element of deception in the fraud. That is only again in the mind of a person, and it cannot be exhibited. Or uses a particular word in a particular sense. A particular word, if it is used in a particular sense, the person using the word only knows in what sense he has used it. Whether he has used in the sense which is generally understood by all, or whether it has got any special significance in a given situation, is a thing which is known to the person who has used that word only. Or was at specified time conscious of a particular sensation, etc., is a fact. So, the word definition of the word fact consists of two parts, clause 1 and clause 2. Clause 1 deals with physical facts, clause 2 deals with mental facts. In this connection, a decision of the Honorable High Court of Karnataka in AIR 1983, Supreme Court, page 446, Irbhadrappa versus State of Karnataka, that a man holds certain opinion, has certain intention, etc., etc. That has been explained in this particular judgment of the Honorable High Court of Karnataka. So anything, state of thing, or relation of things capable of being perceived by the senses are the first category, or any mental condition of which any person is conscious is the second category. So both the categories put together constitute what is called as a fact. Then we will go to fact and issue. Fact and issue is defined in section 2, clause G. Fact and issue means and includes any fact from which, either by itself or in connection with other facts, the existence or non-existence, the nature or extent of any right, liability, or disability asserted or denied in any suit or proceedings necessarily follows. Any fact from which, either by itself or in connection with other facts, the existence or non-existence, the nature or extent of any right, liability, or disability asserted, denied in any suit or proceedings necessarily follows. Here, if we go to if we take, for example, a civil case, what will be the fact and issue? Let us say, for example, X files a suit against Y for a relief of permanent injunction. So he claims to be in lawful possession. He claims to be in possession by virtue of a particular document, whatever it is. And he claims to be in a continuous possession. And he has documents to show the same. And he alleges interference by the defendant. And therefore, he wants protection by way of a decree for permanent injunction by the Honorable Court, restraining the defendant from interfering with his possession. Now, the fact and issue in this case is the defendant appears before the court and denies all the averments in the plaint. Now, Order 14 of the Civil Procedure Code prescribes that when a material fact is denied by one party and when asserted by one party and denied by another party, that leads to a situation where an issue has to be framed. That issue which is going to be framed in a civil case is called as a fact and issue. Is called as a fact and issue. It could be an injunction suit, it could be a money recovery suit, it could be any suit for that matter. So a material fact asserted by one party and denied by other party will give rise to a fact and issue. So whether the plaintiff proves that he is in lawful possession, whether the plaintiff proves that there is an interference by the defendant, whether the plaintiff proves that he is entitled for a decree of permanent injunction. So these are all facts in issue. But in a criminal case, the charge sheet that is filed by the police after investigation will be the fact in issue. Whether the prosecution proves that the accused has committed a particular offense, maybe a murder, maybe a theft, whatever it will be a fact in issue. So fact in issue, keeping this in your background, in the back of our mind, let us see the definition again. Fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability, or disability asserted or denied in any suit or proceedings necessarily follow. Look at the explanation. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact. The fact is to be asserted or denied in the answer to such issue in a fact in issue. That is what I have already explained. So in a civil suit filed by the plaintiff for recovery of money against the defendant, he claims that the defendant borrowed money, agreeing to repay the same along with interest within a stipulated period, and he has executed an on-demand pronote. But whereas on repeated request or demand made, he failed to repay, and a legal notice was issued, and he did not pay, therefore I am filing this suit. And the defendant denies, or the defendant claims that he has paid the amount. Now the question of framing issue arises. Who has to prove what? If he has admitted the execution of the document and claims that he has discharged the whole loan, the burden will be on the defendant to prove, because there is a promissory note, a negotiable instrument which has got a presumptive value. And moreover, he is admitting the borrowing of loan also. Supposing he denies everything, then the burden is entirely on the plaintiff to prove that the defendant borrowed the money mentioned therein, and he has executed the pronote. There was a passing of consideration in the presence of the witnesses, signing of the pronote, etc., etc. All those things will have to be put. So these are the facts in issue. So whether the plaintiff is entitled to recover money from the defendant will be the fact in issue. Look at the illustration. A is accused of the murder of B. At his trial, in that case, the following facts may be in issue at the trial. That A caused B's death. B, that A intended to cause B's death. This is important. No person will murder another without there being an intention in his mind. There should be some motive. There should be some intention behind that particular act. So what was the intention? That A had received grave and sudden provocation from B. Whether the incident has taken place which has culminated into murder because of the grave and sudden provocation given by the deceased. That A at the time of doing the act which caused B's death was, by reason of unsoundness of mind, incapable of knowing the nature. Here it comes the question of clause 2 of definition of the word fact. Supposing a person was intoxicated at the time of committing the offense, or a person was a man of unsound mind at the time of committing an offense, that is a fact to be proved. So this is fact in issue, means the fact in issue, an issue which is fundamental to be proved by the parties, and that will be the fact in issue. Here, I have already given two illustrations. One is with regard to the borrowing of money, another with regard to the permanent injunction, and with one more illustrations we can have. Supposing, let us say that there is a death of a person. In that case, the facts which are required to be proved are, as I've already stated, that accused that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A was mentally unsound at the time of commission of the offense. Now, next definition is relevant fact. Section 2, clause K. Relevant. A fact is said to be relevant. A fact is said to be relevant to another when it is connected with the other in any way referred to in the provisions of this Adhiniyama relating to the relevancy of facts. Let us understand this very carefully. In this Adhiniyama relating to the relevancy of facts, please go to chapter 2 of the Bharatiya Sakshya Adhiniyam. Bharatiya Sakshya Adhiniyam chapter 2 deals with relevancy of facts. This is from section 4 to section 3 is a general section. Section 4 to section 50 are the situations which can be considered as relevant facts. So, relevant fact means a fact is said to be relevant to another. A fact is said to be relevant to another. A X fact is said to be relevant to Y fact, provided that Y fact is connected to X in such a way that it must come under any of the clauses from section 4 to section 50. Otherwise, it cannot be considered as a relevant fact at all. Once again, you look at the definition. A relevant fact is said to be relevant to another when it is connected with the other in any of the ways mentioned from section 4 to section 50. In any of the ways referred to in the provisions of this Adhiniyama relating to the relevancy of fact. So chapter 2 deals with relevancy of fact from section 4 to section 50. So any fact which comes within, I think, any of the provisions from section 4 to 50, if they are connected with the fundamental fact, that is fact and issue, that can be considered as a relevant fact. This is how, according to me, clause K of section 10 section 2 can be interpreted. I have already told that I am not an expert, but to the best of my ability, I am explaining what I have understood from reading of this section. So the fact and issue is of a fundamental importance, and it must be thoroughly comprehended, and relevant facts will have to be understood and appreciated under the scheme of the BSA, that is from section 4 to section 50. A substantive law defines the rights and liabilities of the parties in the form of certain abstract proposition or formulae, and the object of every suit and other judicial proceeding is to define whether the right claimed does or does not exist. Now, which are all the relevant facts as found in chapter 2 of the Evidence Act? Section 3, forget about section 3 better nಮಗೆ. Section 4 to section 14. Facts logically connected with the facts in issue. Section 4 to section 14. Facts logically connected with the facts in issue. BSA, that is Bharatiya Sakshya Adhiniyam. Admissions and confessions, they are also relevant. Section 17 to section 31 of BSA, section 15 to 25 of Indian Evidence, section 17 to 31 of Indian Evidence Act, section 15 to 25 of BSA. Statement by non-witnesses, section 32, 33 of the Indian Evidence Act, section 26 and 27 of the Bharatiya Sakshya Adhiniyam. Statement under special circumstances, section 34 and 37 of the 34 to 37 of Indian Evidence Act, and section 28 to 31 of the Bharatiya Sakshya Adhiniyam. Relevancy of statements, section 38 to 40 of the Indian Evidence Act, section 32 to 34 of BSA. Judgment in other cases, section 40 to 44 of the Indian Evidence Act, section 34 to 38 of the Bharatiya Sakshya Adhiniyam. Opinion of third persons, section 45 to 51 of the Indian Evidence Act, and section 39 subsection 1 and 2, section 40 subsection 1 and 2, and section 42 to 45 are Bharatiya Sakshya Adhiniyam. Evidence as to character, section 52 to 55 of the Indian Evidence Act, section 46 to 50 of the Bharatiya Sakshya Adhiniyam. So, in the Bharatiya Sakshya Adhiniyam, the provisions which are coming from section 4 to section 50 deals with the relevancy of facts. So only such of those facts which have been declared as relevant from section 4 to section 50 can only be considered as relevant, and only such of those facts which are connected to the fact in issue can be considered as a relevant fact. This is how fact in issue and relevant fact will have to be understood. Now, a word about relevancy and admission. All relevant facts may not be admissible in evidence. All relevant facts may not be admissible in evidence, but all facts which are admissible in evidence are relevant facts. All facts which are relevant may not be admissible in evidence, but all facts which are admissible in evidence are relevant facts. merely because a fact is relevant, that does not mean it is admissible. If the law says that such fact, though it is relevant, it is not admissible, it cannot be admitted at all. Take, for example, a provision in the Bharatiya Sakshya Adhiniyam or in the Indian Evidence Act. A communication made by spouses during marriage is a privileged communication and it is not admissible. No doubt, it may be relevant. It may be relevant to prove a particular fact, but whereas the law prohibits using that particular conversation or communication between husband and wife during marriage before the court as a relevant factor. Or between an advocate and his client, though relevant, are not admissible because they are all privileged communications. So there are instances where though the facts are relevant, they are not admissible. They may not be admissible. That is why it is said all relevant facts may not be admissible, but all admitted facts are relevant facts. AR 1998 Supreme Court, page 1850. Rules of relevancy declare certain facts relevant. Rule of admissibility laid down as to whether certain form of evidence about relevant fact may be allowed or excluded under circumstances of a case. What is material fact which may be produced before a court in a case is a first question. Relevancy means what facts may be proved before any court of law. Thus, under Evidence Act, the term relevant or the facts that may be proved are synonymous. The admissibility is means and the method of proving relevant facts is the end. AIR 1998 Supreme Court, page 1850, Ram Bihar Yadav versus State of Bihar. Again, coming to the distinct difference between the admissibility and relevance. Admissibility is not based on logic, but it is based on strict rule of law. Admissibility is not based on logic, it is based on strict rule of law. What do you mean by this? Let us take, for example, a case where a will is in question. Whether X has executed a will in favor of Y or not. I am giving a hypothetical example. How the will has to be proved is a matter which is stipulated in the Evidence Act itself. So, will be admitted in evidence only when the provisions of Section 68 of the Evidence Act and the corresponding provision of BSA is followed. That is, that particular section says that a document which requires attestation may be proved by examining at least one attesting witness alive. So, therefore, the admissibility of the document will depends upon the compliance of the legal provision, that is Section 68 of the Evidence Act. Relevancy is based on logic and probability. So when a question of supposing in the same situation, if X were to say yes, if A were to say yes, X had expressed before me that he wanted to execute a will and he would do so. Now this stands to reason, this stands to logic. And within a few days after such expression with Y, X executes a will. So therefore, that becomes a relevant factor because it stands to logic, it stands to reason. Example I am giving, a hypothetical situation. The rule of admissibility is described after Section 56 of the Evidence Act, that is Section 51 of the BSA. How to admit a particular evidence has been described from Section 51 onwards. Rule of relevancy is described from section 5 to section 55 of the Evidence Act, that is from section 4 to section 50 of the BSA. Rule of admissibility declares whether certain type of relevant is relevant, certain type of evidence is relevant or not. So at the time of admissibility itself, the relevancy will be taken into consideration, and when if it is not relevant, it will be rejected then and there itself. The facts which are admissible are not necessarily relevant. The facts which are relevant and not necessarily admissible. In admissibility, court has no discretion. Court will have to accept it if it is admissible under law. In relevancy, the court has a discretionary power. So these are some of the differences between the admissibility and the relevancy of facts. Now we have seen what do you mean by fact, what do you mean by fact in issue, and what is a relevant fact. Keeping these three things in mind, now we will go to section 3 of the BSA. That is section 5 of the Indian Evidence Act. Chapter 2. Evidence may be given of facts in issue and relevant facts. Section 3. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, and of such other facts as are hereinafter declared to be relevant, and of no others. I have already explained about this, but anyway, let us again look into this provision in this backdrop of having understood what is fact in issue, and a relevant fact. Evidence may be given in any suit. Suit means a civil case, or proceedings, any other proceedings, including criminal case, of the existence or non-existence of every fact. We have seen what the fact is. Fact means a thing or a state of thing or relation of a thing which is perceived by the human senses, or a mental condition of which a person is conscious. We have already seen that definition. So of any fact, that is, evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue. What is fact in issue? We have seen. That is the fundamental fact which has to be proved. As I have already told, an issue framed in a civil case, which is based on the material assertion made by one party and denied by another party, and a charge leveled against a person before a criminal court. So evidence may be given in any suit or proceedings of the existence or non-existence of the fact in issue, and of such other facts as are hereinafter declared to be relevant, and no others. What does it mean? This particular section, according to me, is a mandate. Is a mandate both on the court as well as on the advocates. How? How? Because it clearly says you cannot give evidence of whatever you consider it as necessary. You have to give evidence only relating to the fact in issue, and such of those facts which are considered as relevant under this BSA from section 4 to section 50, and no others. Meaning thereby, when an evidence is sought to be given before the court, a mental exercise is required by the when an evidence is sought to be given before the court, or when an evidence is sought to be entertained by the court by the judge. What is mental exercise that is to be done by the court is whether this particular, or by the advocate is whether this particular evidence that is sought to be tendered has got any relationship with the fact in issue. Whether this particular evidence, either oral or documentary, is in any way going to prove my case involved in the fact in issue, or whether this particular evidence which is given either orally or documentary is in any way a relevant factor which will support the fact in issue, which will support the helping of the proving of fact in issue. These are the two aspects which are to be considered, and no others. That no others, according to me, is a mandate. So that means all evidence which a party considers cannot be entertained by the court, or all evidence that the court considers also cannot be entertained by the court. What has to be entertained is it must satisfy the requirement of section 3 of the BSA. That means that evidence, either oral or documentary, whatever that is going to be produced, must be either related to the fact in issue, or it must be related to any of the relevant facts which are relevant declared from section 4 to section 50 produced to prove the fact in issue. It is only then such evidence can be entertained and no other evidence can be entertained. By using the word and no others and of no others in section 3, according to me, the law has, the Evidence Act has made very clear that evidence can be given only to prove a fact in issue or to prove a relevant fact which will help in turn to prove a fact in issue and nothing else. Look at the explanation. This section shall not enable any person to give evidence of a fact which he is disentitled to prove any provision of law for the time being in force relating to civil procedure. What do you mean by this? According to my understanding, if we go to Order 7, Rule 14 of the Civil Procedure Code, there is a provision. What does it say? According to that particular provision, the plaintiff who wants to rely upon a particular document, when the plaintiff is relying upon a particular document, and when the plaint contains a mention about that particular document on which the suit is based, he must produce the document along with the plaint. Or, if it is not in possession, he must say in whose possession it is. And there is one more rider. No, after this particular stage, no party can produce document on which he is basing his case except with the permission of the court. I may be having a document with me on which my suit is based, but I have not produced it along with the plaint. Subsequently, if I want to produce it, I must take the permission of the court, and though it is relevant, though it is a document connected with fact and issue, I cannot produce it as a matter of right. This is the meaning of the explanation according to me. Now look at the illustrations. A is tried for the murder of B by beating him with a club with the intention of causing his death. At A's trial, the following facts are in issue. A's beating B with club, A causing B death by such beating, A's intention to cause B's death. So these are the facts in issue. A suitor does not bring with him and have the readiness for production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove the contents at a subsequent stage of the proceedings otherwise than in accordance with the Code of Civil Procedure 1908. If I am filing a suit for recovery of the money on the basis of a pronote, I must produce the pronote along with the plaint. If I do not produce along with the plaint, at least I must say where the document is and in whose possession it is. If I don't do either, then I cannot as a matter of right produce it subsequently. And if at all I want to produce, I must take the permission of the court. That means, though the document is very much important to prove the fact and issue, though it is a very relevant document, if it is not produced at the stage at which it ought to have been produced, then you cannot produce it as a matter of right subsequently unless the court permits you. That is the meaning of the explanation according to me. for what reason he had. He had a motive whether he had intention to kill, and what preparations he had made to kill, or the mode or method they were act of killing the person, the bloodstains found on the weapon, bloodstains found on the clothes of the deceased and the accused, postmortem report, serology report, expert opinion, etc., are all the relevant facts of the relevant matters which are connected to the factor issue. Now we will move on to the another important definition of the word document. So we have seen fact, we have seen fact in issue, seen relevant fact, and the difference between the relevant fact and the fact in issue. And now we will move on to the definition document. The word document has been defined in section 2, clause BSA. And all definitions are found in section 3 of the Evidence Act. Document means any matter expressed or described or otherwise recorded upon any substance by means of letters or marks or any other means or more than one of those means intended to be used or which may be used for the purpose of recording that matter and in electronic and digital record. In this definition, the words that are added in BSA are otherwise recorded. Document means any matter expressed or described. That was all found in the Evidence Act. Or otherwise recorded has been added. And other addition is includes electronic and digital records. That is the further addition in the BSA which was not found in the Evidence Act. I think so. So just for a correction. Clause 3 document. Yes. Now, what do you mean by otherwise recorded? Otherwise recorded means it gives a further expansion and widens the scope of recording in any other forum which is not covered in the forum already described in this section. Andre otherwise recorded ಅಂತಂದ್ರೆ ಇವಾಗ ಆವಾಗಲೇ ಈ ಸೆಕ್ಷನ್ ಈ ಕಾಲಮ್ ಡೆಫಿನೇಷನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನೋ ಡೆಫಿನೇಷನ್ ಅಲ್ಲಿ ಏನೇನು ಹೇಳಿದ್ದಾರೆ. ಉದಾಹರಣೆಗೆ ಅಪಾನ್ ಎನಿ ಸಬ್ಸ್ಟೆನ್ಸ್ ಬೈ ಮೀನ್ಸ್ ಆಫ್ ಲೆಟರ್, ಫಿಗರ್ ಆರ್ ಮಾರ್ಕ್ಸ್ ಎಟ್ಸೆಟ್ರಾ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಇನ್ಯಾವುದೇ ರೂಪದಲ್ಲಿ ಅದನ್ನು ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡಿದ್ರು ಸಹ that is also included. So this particular definition gives a wide scope for including any sort of document, any sort of a thing which can be considered as a document within the meaning of this particular clause. So document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures or marks, any other means or more than one of those means intended to be used or which may be used for the purpose of recording that matter. Supposing a person dies in a family and he will be buried in the farmhouse. There they will erect a stone along the ಮರಣಶಾಸ್ತ್ರದ ಕಲ್ಲು ಹಾಕ್ತಾರೆ. ಹುಟ್ಟಿದ ದಿನಾಂಕ, ಸತ್ತ ದಿನಾಂಕ ಅಂತೆಲ್ಲ ಬರೆದೆಲ್ಲ ಹಾಕ್ತಾರೆ. That is a thing which is engraved on a stone by means of letters, numbers, figures, and that also becomes a document. So any example ಹೇಳ್ತಿರೋದು ಬರೀ ಕಾಗದ ಬರೆದ್ರೆ ಕಾಗದಗಳ ರೂಪದಲ್ಲಿ ಇದ್ರೆ ಮಾತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಗುದಿಲ್ಲ. ಅಥವಾ ರಿಜಿಸ್ಟರ್ ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಬರೆದಿದ್ರೆ ಮಾತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಆಗುದಿಲ್ಲ. ಒಂದು ಮರದ ಮೇಲೆ ಬರೆದಿರ್ಲಿ, ಒಂದು ಕಬ್ಬಿಣದ ಮೇಲೆ ಬರೆದಿರ್ಲಿ, ಗೋಡೆ ಮೇಲೆ ಬರೆದಿರ್ಲಿ, ಯಾವುದ್ರ ಮೇಲಾದ್ರೂ ಬರೆದಿರ್ಲಿ, ಅದೇನಾದ್ರೂ ಯಾವುದೇ ಒಂದು ಕೇಸಿಗೆ ಅವಶ್ಯಕತೆ ಇದ್ರೆ, if it comes under any of the relevant fact or a factor issue, that becomes a document. So document means any matter expressed or described, otherwise recorded upon any substance. Substance means ಕಾಗದ ಇರ್ಬೋದು, ಗೋಡೆ ಇರ್ಬೋದು, ಮರ ಇರ್ಬೋದು, ಕಬ್ಬಿಣ ಇರ್ಬೋದು, ಕಲ್ಲು ಇರ್ಬೋದು, ಇನ್ನು ಮಗದೊಂದು ಇರ್ಬೋದು. Any letters, figures or marks or any other means, or by more than one of the means intended to be used or which may be used for the purpose of recording that matter. ಯಾವುದೇ ಒಂದು ವಿಷಯವನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಈ ಯಾವುದೇ ಒಂದು ಸಬ್ಸ್ಟೆನ್ಸ್ ನ ಉಪಯೋಗಿಸ್ಕೊಂಡು ಅದ್ರ ಮೇಲೆ ಬರೆದಿದ್ರು ಸಹ, ಅದು ಫಿಗರ್ಸ್ ಆಗಿರ್ಬೋದು, ಲೆಟರ್ಸ್ ಆಗಿರ್ಬೋದು, ಮಾರ್ಕ್ಸ್ ಆಗಿರ್ಬೋದು, ಏನೇ ಆಗಿರ್ಬೋದು, ಅದು ಸಹ ಡಾಕ್ಯುಮೆಂಟ್ ಆಗುತ್ತೆ. ಲುಕ್ ಅಟ್ ದಿ ಇಲಿಸ್ಟ್ರೇಷನ್ಸ್. ಎ ರೈಟಿಂಗ್ ಇಸ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್. ಸೊ ಯಾವುದೇ ಒಂದು ಕಾಗದ ಬರೆದೆ, ಯಾವುದೇ ಒಂದು ಪತ್ರ ಬರೆದೆ, ದಟ್ ಇಸ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್. ಪ್ರಿಂಟೆಡ್, ಲಿಥೋಗ್ರಾಫ್ಡ್ ಆರ್ ಫೋಟೋಗ್ರಾಫ್ಡ್ ಆರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಪ್ರಿಂಟ್ ಮಾಡಿರೋದು, ಲಿಥೋಗ್ರಾಫ್ ಮಾಡಿರೋದು, ಫೋಟೋಗ್ರಾಫ್ ಮಾಡಿರೋದು ಡಾಕ್ಯುಮೆಂಟು. ಎ ಮ್ಯಾಪ್ ಆರ್ ಎ ಪ್ಲಾನ್ ಇಸ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್. If I have obtained a sanction plan from the municipality for the purpose of constructing a house, that becomes a document. Or if I have prepared even a rough sketch, that becomes a document. Or plan is a document. An inscription, a metal plate, an inscription on a metal plate, ಯಾವುದೇ ಒಂದು ಕಬ್ಬಿಣದ ಪ್ಲೇಟ್ ಮೇಲೆ ಏನಾದರೂ ಬರೆದಿದ್ರೆ, ಅಥವಾ ಒಂದು ಫಿಗರ್ ಇರ್ಬೋದು, ಒಂದು ಸಂಖ್ಯೆ ಇರ್ಬೋದು, ಒಂದು ಹೆಸರು ಇರ್ಬೋದು ಬರೆದಿದ್ರೆ, or a stone is a document. A caricature is a document. Caricature is a ವ್ಯಂಗ್ಯಚಿತ್ರ. Caricature is a document. And lastly, which has been added by BSA, an electronic record. An electronic record on emails, surlogs, documents on computers, laptops, smartphone, messages, websites, locational evidence, and voice, mail messages stored on digital devices are all documents. So this clause number 6, illustration number 6, is addition that has been made in BSA, which was not found in the Evidence Act. Now this has a wider meaning, and opens a very wide scope for understanding. An electronic record on emails, server logs, documents on computers, laptops, smartphone, messages are all coming under the definition of a document. So whenever or wherever the word document is used, the context will have to be kept in mind, include in our mind that these documents also, it could be an electronic message, it could be a WhatsApp message, it could be some message sent on Instagram, or it could be any other social media or an email, etc., whatever that is mentioned, either from the mobile or from the laptop or from the computer, whatever it is, all those things are coming within the definition of a document. Now here, when we are talking of document, electronic record on emails. Of course, after taking the word evidence, I will explain. So these are all the documents within the meaning of the clause D of the Evidence Act. Sorry, BSA. Now we will take evidence and then explain the electronic records and digital records. Evidence means all statements, including statements given electronically, which the court permits or requires to be made before it by a witness in relation to matters of fact under inquiry, and such statements are called oral evidence. Let us understand this. All statements, including statements given electronically. So even if a statement is recorded on a computer, that is also an evidence within the meaning of the Evidence Act, which the court permits. So the court should permit. Merely because you produce some document which is prepared from electronically from a computer or a phone or a laptop, court need not accept it. The court will permit only if other conditions under the BSA are satisfied. So the court permits. And if the particular document is not relevant or if the particular document is not anywhere connected with the fact in issue, the court may not permit us to produce the document at all. So which the court permits? So the document, any statement, including the statement recorded electronically, only when the court permits, or requires to be made before it by witnesses in relation to matters of fact. What does it mean? I have already explained in the beginning of this session that best evidence rule. That means if I have a best evidence with me to prove my case, whether a documentary or a oral evidence, I must produce it. If I don't produce it, if I don't give satisfactory explanation for not producing it, then I may not be in a position to get the relief which I have sought. So I am bound to use it. If I withhold it or if I suppress it, then I will be guilty of suppression of facts. So that is the meaning of saying required to be made before it by witnesses. I have to. The witness means party is also a witness. I have to produce that particular witness. I have to produce that particular document. Or even if a witness comes, he says that he has a document to prove a particular fact, he must produce that document or produce that evidence. So a statement including statements given electronically, which the court permits, number one, are required to be made by witness. Witness party is also a witness under the CPC. Party is also a witness. So I am required to produce it. If I don't produce it, I have that evidence. I say that I have got the evidence. I am bound to have that evidence. If I don't produce it, the court will draw adverse inference against me, witness. And in respect of what? In respect of matters under inquiry. So whatever the evidence, documentary evidence that I produce, it must be only in respect of the matter under inquiry, that is fact and issue. And such statements are called oral evidence. So when a statement is given, either including the statement given electronically, and when the court permits, or which I am bound to give such evidence to witnesses, that is called as a oral evidence. All documents, subclass 2, all documents including electronic or digital records. Now here the word digital record is used. Produced for the inspection of the court, and such documents are called documentary evidence. So here electronic and digital record is an addition that has been made, and in the clause 1, including statement given electronically is the addition that has been made in BSA, which was not found in the Indian Evidence Act. Now, let us understand what do you mean by electronic record or digital record. The digital records are scanned or photographed physical documents, example PDF, while electronic records are system native files like emails, databases. The key differences include in its origin, the converted versus born digital, accessibility, portable, software dependent. Examples are, the digital records examples are scanned documents, photographs, digital audio files. Again, the examples of digital records are scanned documents, photographs, digital audio and video films, e-books and PDFs, digital artwork. The examples of electronic records are emails and attachment, databases, spreadsheets, software applications, web pages, and blogs, BLOGs. A digital record is a document that originated in the digital form. It is often a digital analog of a physical record, such as PDF of an application, firm, legal document, or invoice. If you have ever asked what is digital copy of a document, this is the simplest way to think about an usable version of a paper recorded, captured, or created digitally. If I make a payment of rupees 100 in a shop through Google, whatever that appears as a document in the in my Google Pay app, that becomes a document that can be scanned or that can be photographed or that can be shared. So that is a digital record. Example I'm taking. Digital record can be easily transmitted electronically and modified, but they can also be printed out, making them a highly versatile component in internal workflow, etc. So these are the documents include electronic or digital record produced for the inspection of the court. And such documents are called documentary evidence. So naturally, whenever a document is produced before the court, the simple test that is to be satisfied by the party is whether the document is original, or if it is a copy, what has happened to the original, and what steps have been taken by a party to secure the original document, and whether that particular document is relevant for the purpose of the case, either to prove the factual issue, and whether that particular document is stamped. If not properly stamped, what is the stamp that has to be given, and whether that particular document has been registered. All those things will have to be examined, and all subject to all these examinations only, a document can be admitted evidence, and that can be considered as a documentary evidence. So this is insofar as document is concerned. We will move on to presumptions. This is Section 4 of the Indian Evidence Act. And Section 4 deals with may presume, shall presume, and conclusive proof. Here in BSA, you find may presume in clause H. You find shall in Section 2, clause L. In presumption can be defined as not be a legal definition, of course, but in the ordinary sense, it can be defined as presumptions or inferences which can be drawn from either from the proved facts or from the known facts. Either from the proved facts or from the known facts. A simple definition of presumption. I want to have a little more legal definition. It can be said like this. Presumption is a legal or a factual assumption drawn from the existence of certain facts. The presumption drawn under statute has only an evidentiary value. The presumption drawn in respect of one fact may be an evidence even for the purpose of drawing presumption in respect of another fact. So a simple definition is a presumption one which is a presumption can be defined as an inference which is drawn from either facts or known facts. How? We will see. The phrase may presume has been defined under BSA and also in the Evidence Act as wherever it is provided by this act that court may presume a fact. Court may presume fact. It may be either regard. It may be either regard such fact as proved. It means court. Court may either regard such fact as unless and until it is disproved, may call for the proof of it. What do you mean by this? If you read the evidence, there are certain sections where it is mentioned that the court may Hello?
My lords, not audible.
Hello?
I think there's some glitch, my lords. I'll rectify it, my lords. Give me a minute.
ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅನ್ ಮಾಡಿದ್ದೀನಲ್ಲ ನಾನು.
My lords, internet problem ಇರಬೇಕು. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ
ಪ್ರಾಬ್ಲಮ್
my
ಆಗಿದೆ.
lords ಈಗ. ವರ್ಕ್ ಆಗ್ತಿದೆ my
ಅಲ್ಲ
lords.
ನಾನು ಕೇಳಿಸುತ್ತಾ ಇವಾಗ?
ಕೇಳಿಸ್ತಿದೆ my lords.
ಕೇಳಿಸುತ್ತಾ?
ಕೇಳಿಸ್ತಿದೆ.
ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಹೌದು my lords, ಕೇಳಿಸ್ತಿದೆ.
ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದಾ?
ಮಾಡಿ my lords, ಪ್ಲೀಸ್.
ಯಾಕೆ ಎನಿ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ದೇರ್?
ಗೊತ್ತಾಗ್ತಿಲ್ಲ, ತಮ್ಮ ಇಂಟರ್ನೆಟ್ ಪ್ರಾಬ್ಲಮ್ ಇರ್ಬೋದು. ನಮ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ವರ್ಕ್ ಆಗ್ತಿತ್ತು.
ನಮ್ಮಲ್ಲಿ ಏನಿಲ್ಲ, ನನ್ನಲ್ಲಿ ಏನು ಕಾಣ್ತಾ ಇಲ್ಲಪ್ಪ ಇಲ್ಲಿ.
ಅದೇನೋ ಗೊತ್ತಿಲ್ಲ my lords, ಗ್ಲಿಚ್ ಇರ್ಬೋದು ಅನ್ಸುತ್ತೆ. ಈಗ ಕರೆಕ್ಟ್ ಆಗಿದೆ my lords, ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು.
ಇವಾಗ ಓಕೆ ಓಕೆ
ಕರೆಕ್ಟ್
ಓಕೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಪ್ಲೀಸ್ my lords, ದಯವಿಟ್ಟು.
ಥ್ಯಾಂಕ್ ಯು. ಕೇಳಿಸ್ತಿಲ್ಲ ಅಂತ ಯಾರೋ ಬರ್ದಿದ್ರೆ? ಆಮ್ ಐ ಆಡಿಬಲ್? ಹಲೋ?
my lords, ಕೇಳಿಸ್ತಿದೆ, ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಕೇಳಿಸ್ತಿದೆ, ಓಕೆ. ಸೊ presumptions are the inferences which are drawn from either the known facts or from the proved facts. Known or proved facts. There are two classes of presumptions: may presume, shall presume. May presume has been defined in section 2, clause L of the BSA. 1 minute. Section 2, clause H of BSA. Wherever it is provided by this act, that is by this Adhiniyam, that the court may presume a fact. It may be either regard such fact as proved unless and until it is disproved, or may call for it. So there are number of sections where you find the word may presume. So wherever the word may presume is there, the option given to the court is either it can take the fact or the court may call for the proof of it. For example, you go to section 109 of the BSA. A person in possession of a stolen property soon after the theft, and court may presume, section 109 Purti may presume. A person who is in possession of stolen property soon after the theft is either a thief or a receiver. A person who is in possession of a stolen property which is stolen soon after the theft, he would to be either a thief or a receiver. ಯಾವುದು ಕಳವಾಗಿರ್ತಕ್ಕಂತಹ ಹೊತ್ತಿನಲ್ಲಿಯೇ ಇನ್ನೊಬ್ಬನ ಸ್ವಾಧೀನದಲ್ಲಿದೆ ಅಂತಂದ್ರೆ ಅವನು ಇಲ್ಲ ಕಳ್ಳ ಆಗಿರ್ಬೇಕು, ಇಲ್ಲ ಕಳ್ತ ವಸ್ತು ಕೊಂಡನಾಗಿರ್ಬೇಕು. ಸೊ ಅವನ ಹತ್ರ ವಸ್ತು ಇರೋದಕ್ಕೆ ಸರಿಯಾಗಿರ್ತಕ್ಕಂತಹ ಕಾರಣವನ್ನ ಕೊಡದೇ ಇದ್ರೆ ದ ಕೋರ್ಟ್ ಮೇ ಪ್ರಿಸ್ಯೂಮ್ that either he is a thief or a receiver of stolen property. Example ನಾನು ಹೇಳ್ತಿರೋದು. So this is how the word may to be done. Not accounted properly ಅಂತಂದ್ರೆ ಏನಂತ? I draw your attention to one of the provisions of the Karnataka 98 ಇರಬೇಕೇನೋ 98. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, whenever a person found in possession of a stolen property, if he fails to account this, he is punishable with an so fine, etc. A complaint for the police, and one Mr. X was found with the motorbike soon after the commission of the theft. Now, that X will have to explain as to how he came in possession of that particular motorbike. If at all he has not stolen it, not it as a stolen, knowing it as a stolen time. Explanation and accept that explanation, and then said to be disproved that he is not a thief. I'm only giving an hypothetical example. With reference to clause 1 of section 100 and the course of human conduct, the court may presume that any person who is in possession of stolen property soon after the theft is either a thief or a receiver of stolen property, unless he accounts for the possession. Unless he accounts for the possession. So presume will have to be understood. Let us take one example of a civil case. A statutory notice has to be issued. The plaintiff will take up a contention that he has issued a notice. The defendant denies it. The defendant uses the copy of the notice along with the plaintiff and evidence. Now, whether that particular production of a copy of a notice itself is sufficient for the court to presume that the notice has been served? No. Because that copy of the notice must have been accompanied by a postal receipt for having sent that copy through RPAD, number one. That postal receipt must bear address or carry the address of the recipient correctly. It must be properly addressed. And he must have paid the fee as payable at the postal rules. So it must be properly addressed, proper stamp must have been paid, and it must be dispatched. In the absence of the documents, mere production of a copy notice may not meet the requirements of law. This has been issued unless it is, then the court may call upon the plaintiff to that the notice has been actually sent and it is served upon the defendant. So these are some of the examples which can be given. If you read section 114, there are a number of instances where the court can presume certain things. The sections which are found in BSA, where the word may presume is used, are as under section 88 of the BSA. Presumption as to certified copies of foreign judicial records. There it is only may presume. Section 18. Section 87 of the Indian Evidence Act, Section 89 of the BSA. Presumption as to books, maps, and charts. Section 90 of the BSA, Section 88A of the Indian Evidence Act. Presumption as to electronic messages. Section 5. Serial number 5. Section 92 of the BSA, Section 90 of the Indian Evidence Act. Presumption as to documents of 30 years of the Indian Evidence Act. Presumption as to electronic records of world. Section 117, that is Section 113A of the Indian Evidence Act. Presumption as to abetment of suicide by a married woman. Section 119 is Section 114 of the Indian Evidence Act. These are the sections where find the word may presume. So wherever the word may presume is given, the discretion is given to the court. The court may presume that particular fact has been put in respect of a document where the court in respect of a fact may presume. So for the Indian Evidence Act, where it says that when a married woman commits a suicide within 7 years marriage, it is proved that suicide, she was subjected to the court may presume that the husband or the relatives of the husband have abetted. The fundamental aspect have to be proved. Then the court may draw a presumption that the fact has been proved. Or if the opposite side is able to produce a more stronger evidence, disprove or rebut that presumption, the court may proof of it. This is how the word may presume will have to be interpreted according to me. Then you come to shall presume. This is found in section L of BSA and in section 3 of the Indian Evidence Act, where it is directed by this Adhiniyam that the court shall presume a fact. It shall regard such fact as proved. We either regard such fact as proved unless and until it is disproved. Look at the difference between the presume and shall presume. In case of may presume, the discretion is given to the court. The court presume the existence of the particular fact or presume a particular fact or may not the proof of it, or if it is disproved, may not accept it. But in case of shall presume, it is not. So wherever shall presume used in the Adhiniyam, the sections of Adhiniyam, then the court will have shall presume, shall prove under presumption. Rebutting that presumption is on the other side. So if the other side fails to disprove that, then the court will automatically draw presumption in favor of the particular fact. The best example that can be given is a dowry debt. Section 104 B of the Indian Evidence Act, Indian Penal Code, the equivalent a woman dies of or body or under circumstances unnatural. And if it is proved that she dies within 7 years from the date of marriage, and if it is proved that soon before her death, she was subjected to cruelty, either by the husband or his relative, in connection with the demand for dowry, it is called as a dowry death. This is what Section 4B says. Now, corresponding provision in the Evidence Act to be considered is Section 100 in B, I suppose. 1 minute. Presumption as to dowry death. What does it say? When a question is whether a person has committed the death, what is dowry death has been defined in Section 304B. When a question is whether a person has committed the dowry, whether a person has committed a dowry death of a woman, and it is shown that soon before her death, such woman had been subject to such person to cruelty or harassment for or in connection with the demand for dowry, the court shall presume that such person had caused the dowry death. So, we have to read this particular section with Section 304B, wherein it is stated that when a married woman dies of burns, suttukondu, or bodily injury, or under circumstances other than natural, ಅಸ್ವಾಭಾವಿಕವಾಗಿ ಹೊಂದಿದ್ದ ಪಕ್ಷದಲ್ಲಿ, ಅಂತಹ ಸಾವು ಆಕೆ ಮದುವೆಯಾದ 7 ವರ್ಷದ ಒಳಗೆ ಆಗಿದ್ದ ಪಕ್ಷದಲ್ಲಿ, ಮತ್ತು ಆಕೆ ಆ 7 ವರ್ಷದ ಸೂನ್ ಬಿಫೋರ್ ಹರ್ ಡೆತ್, ಅವಳು ಸಾಯೋದಕ್ಕೆ ಪೂರ್ವದಲ್ಲಿ, ತಕ್ಷಣ ಪೂರ್ವದಲ್ಲಿ ಆಕೆ ಗಂಡ ಅಥವಾ ಆಕೆ ಸಂಬಂಧಿಕರು ಅವಳನ್ನ ಕಿರುಕುಳ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಡೌರಿ ವರದಕ್ಷಿಣೆಗೆ ಸಂಬಂಧವಾಗಿ ಕಿರುಕುಳ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅನ್ನೋದು ಪ್ರೂವ್ ಆದ್ರೆ, ಇಫ್ ಇಟ್ ಈಸ್ ಶೋ ತೋರಿಸಿದ್ರೆ, ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಎ ಡೌರಿ ಡೆತ್. 118 ಓದಿದಾಗ, when the question whether a person dowry death, ಆಕೆ ವರದಕ್ಷಿಣೆ ಕಾರಣ ಉಂಟು ಮಾಡಿದಾನ ಇಲ್ವಾ ನ್ಯಾಯ ಮುಂದೆ, if it is shown before her death, subjected cruelty in connection ಪ್ರೂವ್ ಮಾಡಿದ್ರೆ, ನ್ಯಾಯಾಲಯ ಆ ವ್ಯಕ್ತಿನೇ ಆಕೆಯ ಸಾವಿಗೆ ಕಾರಣ ಅಂತಂತಹ ಸಂಪೂರ್ಣವಾಗಿ ಪರಿಭಾವಿಸಬಹುದು. shall presume unless it is rebutted. ಅವಾಗ burden is on the husband or the relatives, ಯಾರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇರ್ತಾರೋ ಅವರಿಗೆ, to prove that it was not a dowry death. So this is the difference between may presume and shall presume. Take for example Section 133 of the Karnataka Land Revenue Act, where it is stated that an entry in the revenue RTC extract and other revenue records shall be presumed to be correct unless it is substituted by a lawfully made entry. It may happen in so many cases where the plaintiff will produce certain RT extracts, defendant will produce certain RT extracts, plaintiff will produce RTC extracts up to a particular year. Say, for example, the suit is 2000, the plaintiff produces RTC extract up to 1999, 88, 99. From 2000, 2001 onwards, defendant produces RTC extract. Now, which one will have to be believed? When the question arises, this Section 130 will come into picture. What does it say? So, an entry in the revenue record shall be presumed to be correct unless it is substituted by a lawfully made entry in accordance with the Karnataka Land Revenue Act itself provides as to how a submission of entry will be made. And after all of a sudden, if it appears in the name of the defendant in 2000, 2001, how it would appear? Unless the procedure is followed, unless notice is given to the person who is already shown, whose name is already shown in the RTC extract. So the defendant will have to show that the entry from 2000 to 2000 is a lawfully substituted entry. If it doesn't show it, then the RTC extract produced by the plaintiff will be presumed to be correct. So this is how the word shall presume and may presume will have to be interpreted. Take for example Section 118 of the Negotiable Instrument Act, where also it is provided regarding shall presume. So there are so many provisions where it is provided the court shall presume, not only in the BSA but also in other enactments. So you can find such a provision. To the BSA, the sections where shall presume is used are as under Section 78 of the BSA, Section 79 of the Indian Evidence Act, presumption as to genuineness of certified copies or certificate which the law declares to be admissible in evidence. Supposing a certified copy of a judgment passed in a particular case is produced before the court, you cannot doubt it. It shall be presumed as correct. It shall be presumed as correct. Section 79 of the BSA, Section 80 of the Evidence Act, presumption as to record of evidence. Section 80 of the BSA, 81 of the Indian Evidence Act, presumption as to gazettes, newspapers, and other documents. Section 81 of the BSA, Section 81 of the Indian Evidence Act, presumption as to gazettes and gazettes in electronic or digital form. Section 82 of the BSA, Section 83 IEA, that is Indian Evidence Act, presumption as to maps, plans made by authority of the government. Authority of the government. ಸರ್ಕಾರದ ಆದೇಶದ ಮೇರೆಗೆ ತಯಾರಾಗಿರ್ತಕ್ಕಂತಹ ಮ್ಯಾಪ್ಗಳು ಮತ್ತು Section 80 of the BSA, Section 84 of the Indian Evidence Act, presumption collection of laws and reports of the IEA of the presumption as to power of attorney. Section 85, BSA, Section 85A of the Indian Evidence Act, presumption as to electronic agreements. Section 86 of the BSA, Section 85B of the Indian Evidence Act, presumption as to electronic records and electronic signature. Section 87 of BSA, Section 85C of the Indian Evidence Act, presumption as to electronic signature and signature certificates. Section 91 of the BSA, Section 89 of the Indian Evidence Act, presumption as to due execution, etc. of the documents not produced. Supposing I say that I have got a particular document to produce with me to show to a particular fact, but I don't produce it. I don't produce it. So when a particular fact can be proved by producing a document, which is admitted to be in my possession, then what happens? The law says the court can presume that such document was duly executed, and court can draw adverse inference against me for not having produced it. Section 115, the BSA, Section 111A of the Indian Evidence Act, presumption as to certain offences. Section 118 of the BSA and Section 113B of the Indian Evidence Act, which I have already read, presumption as to dowry death. Section 120, that is Section 114A of the Indian Evidence Act, presumption as to absence of consent in certain prosecution for rape. These are the sections where you find the shall presume. So wherever the word presume is, the court has to take it on the other side to prove it. Court did not call for the other party to either dispute. Court even need not call the party to prove it, because the court has to draw presumption of a particular party. So this is the difference between may presume and shall presume. And lastly, conclusive proof. B of Bharatiya Sakshya Adhiniyam and Section Indian Evidence Act. Conclusive proof means when one fact is declared by this Adhiniyama to be the conclusive of another, the shall, on proof of one fact, regard the other as proved and shall not allow the evidence to be given for the purpose of disproving it. It is more strongly assumed. What do you mean by this? The meaning is one fact is declared by Adhiniyama to be conclusive proof of what the other has proved and shall allow the evidence to be given for the purpose of disproving it. For this, I will draw your attention to Section 116 of the Bharatiya Sakshya Adhiniyam. Birth during marriage, conclusive proof of legitimacy. The fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate child of that man. What do you mean by this? Supposing a woman delivers a child, Now, the question is whether that particular child was born to her during the continuance of her marriage with X. X is the husband, that woman is the wife. Mother is always true. So that mother delivers a child. And that X disowns that child as his child. Now the dispute is whether that particular child is born to her through him under a valid marriage. The law says the fact that any person is born during the continuance of the valid marriage. So when that X and this woman are married, and when their marriage was subsisting, during the continuance of that valid marriage, if that woman delivers a child, then it is presumed, then it's a conclusive proof that that person who is newly born is the person who is born to that X, that is the husband. Going further, let us say, for example, that woman and that particular X, that is husband and wife, got themselves separated. If that child is born within 280 days from the date of separation, and if that woman remains unmarried, then also the law says that the person born to that woman within that period of 100 and 280 days is the person born to her through her husband. So this is a conclusive proof. So this is one of the example where this is one of the section where there is a provision of conclusive proof. And one more section which you find in the evidence is section 55 of the Bharatiya Sakshya Adhiniyam. So that is with regard to relevancy of certain judgments in probate, etc. jurisdiction. There also the word conclusive proof is used. So now we have seen the various aspects with the two different categories of law, that is procedural law and substantive law. What is procedural law and what is substantive law we have seen. And we have seen because as I've already told you, taking for example, in the case of an Indian Penal Code or a Bharatiya Nyaya Sankita, they only say which are all the penal provisions. But how to that offense in mind one situation in
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್. ಸ್ವಲ್ಪ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಏನೋ ಶೇಕಿ ಇದೆ ಅನ್ಸುತ್ತೆ, ಸ್ವಲ್ಪ ಮಧ್ಯ ಬ್ರೇಕ್ ಆಗ್ತಾ ಇದೆ. ಅದರ್ವೈಸ್ ತಮ್ಮ ವಾಯ್ಸ್ ಚೆನ್ನಾಗಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಬಟ್ ಇಂಟರ್ನೆಟ್ ಸ್ವಲ್ಪ ಶೇಕಿ ಇದೆ ಅನ್ಸುತ್ತೆ, ಮಧ್ಯ ಕೆಲವು ಗೊತ್ತಾಗ್ತಾ ಇದೆ. ಇವಾಗ ಪೂರ್ತಿ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್, ಫುಲ್ ಬ್ಲಾಂಕ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
Am I audible, sir?
Now you are audible, sir, but in between we had lost the voice, sir, completely. ಇಲ್ಲ ಸರ್, ಅದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಅದು ಕಾಣಿಸ್ತಾ ಇದ್ದೀರಾ ತಾವು, ಬಟ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್, ಪೂರ್ತಿ ಬ್ಲಾಂಕ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು. ಅದು ಇಂಟರ್ನೆಟ್ ಬಹುಶಃ ಸ್ಟೇಬಲ್ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ, ಅದಕ್ಕೆ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Can you not hear me?
Now we are able to hear you, sir, but we were not able to hear you a while ago.
ನಿಮಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ? Okay. Okay. I will repeat. I will repeat what I said 3 minutes back.
Yes, sir. Please, sir.
So we have already discussed about substantive law and procedural law. And while discussing on procedural law, I have told about CPC and CRPC. And I was drawing attention to the Criminal Procedure Code, Bharatiya Nagarika Suraksha Samhita, aspect of penal laws. Section 4 of the Criminal Procedure Code or Section 4 of the BNSS says that all investigations, inquiry, and trial in respect of the offence under BNS or IPC will have to be conducted according to BNSS or IPC, Criminal Procedure Code. So therefore, that procedural law will determine as to how to bring a person who has committed an offence on record and punish him according to the law well established. And we have also discussed the need for bringing the BA, and we have also discussed about some of the important definitions like fact and issue, relevant fact, may presume, shall presume, conclusive proof, document, evidence, and all that. So I think with this we can close the session if Mr. Trivikram sir permits me.
We will just ask our participants if they have any doubts, sir. So if you permit me, we will ask for Q&A session, sir. Very quickly.
Certainly, sir. Certainly.
Yes, very quickly, I would request all the participants to send any queries through the chat box so that we will pose it before our resource person and sir would be answering those queries. Of course, for some time we had some glitches. So if you have any doubts, I would request you to immediately send it through the chat box. Yes, I saw some message coming in. Difference between electronic and digital record.
Yes. Digital records are scanned or photographed physical documents. Example, PDF. While electronic records are system native files, they are embedded in the system itself, like emails, database, etc. They are found in the system itself. But whereas scanned copies, you can scan any document and share it with somebody else, or send it to authority to whomsoever you want to send it. That is the main difference. Digital electronic records, examples are scanned documents, photographs, digital audio and video files, records, examples are, I have already shared emails, database, etc. This is the difference between the email and digital.
Yes,
I have
sir.
also given an example. Supposing you go to a shop, buy something, pay money through your Google Pay app. That will be recorded in the Google Pay app to whom you have made payment. You can take the copy of that particular receipt, whatever it is that is found, or scan it and send it to a person to whomsoever you want to send. So that is one of the best example of a digital record. Any other question?
Yes, sir. Mr. Samarth has this question. Sir, in the criminal case, does the same principle of Section 3 of the BSA in accordance of explanation part such that production of evidence follows if not given during the filing of the suit? I don't know, he's using suit and criminal case. Let me
That's correct,
repeat this, sir. Sir, in the criminal...
Explanation to Section 3. I have understood the question, sir.
Yes.
ಅವ್ರ ಪ್ರಶ್ನೆ ಏನು ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 3 ಇರ್ತಕ್ಕಂಥ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಪ್ಲೈ ಆಗುತ್ತಾ ಅಂತ. ಮೈ ಆನ್ಸರ್ ಈಸ್ ಸೆಕ್ಷನ್ 3 ನ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ದಯವಿಟ್ಟು ನೋಡಿ, ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಅಂತಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಅಂತ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ. ಇನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ದಿಸ್ ಸೆಕ್ಷನ್ ಶಲ್ ನಾಟ್ ಎನೇಬಲ್ ಎನಿ ಪರ್ಸನ್ to give evidence of a fact which he is disentitled to prove by any provision of the law for the time being in force relating to civil procedure. So when the explanation itself is very clear, I don't think that this question, I don't know why this confusion has come, I don't know. Yes, any other question?
Yes, Mr. Samarth, sir has clarified it. You may please read the explanation under section 3. Any more questions? Quickly, I would request you to pose it. Otherwise, we'll be winding up the session very quickly. And Samarth has thanked you, sir, for the answer. ಬೇಗ ಯಾವ್ದಾದ್ರು ಕ್ವಶನ್ಸ್ ಇದ್ರೆ ಕೇಳ್ಬಿಡಿ, ಸರ್ನ ವೇಟ್ ಮಾಡ್ಸೋದು ಬೇಡ. ಇಲ್ಲ ಅಂತಂದ್ರೆ
ಏನ್ ಪರವಾಗಿಲ್ಲ, ತಗೊಳ್ಳಿ
ಸೆಷನ್.
5 ನಿಮಿಷ ತಗೊಳ್ಳಿ, ಏನ್ ಚಿಂತೆ ಇಲ್ಲ. ಐ ಕ್ಯಾನ್ ವೇಟ್ ಫಾರ್ 5 minutes, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಎಸ್ ಸರ್.
ಗೊತ್ತಿದ್ರೆ ಹೇಳೋಣ, ಅದಕ್ಕೇನಂತೆ.
ಕರೆಕ್ಟ್. ಸದ್ಯಕ್ಕೆ ಯಾವುದು ಬಂದಿಲ್ಲ ಸರ್. ಇನ್ನೊಂದು 1 minute ನೋಡ್ಬಿಟ್ಟು ವಿಲ್ ವೈಂಡ್ ಅಪ್ ದ ಸೆಷನ್. I repeat, if any of the participants have any doubt, please pose it. We had Mr. Samarth and we had Mr. Surya Nair having doubts. They have got it clarified. It's an opportunity to interact with a resource person. Sir, CBI court ಅಲ್ಲಿ ಇದ್ರು. ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಕೂತ್ಕೊಳ್ಳೋದಕ್ಕೆ ಬಹಳ ಚೆನ್ನಾಗಿರ್ತಾ ಇತ್ತು. ಹಾಗಾಗಿ anyway, you're also very lucky because ಅವ್ರ ಕೈಲಿ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಕೇಳುವಂತ ಸೌಭಾಗ್ಯ ಸಿಕ್ಕಿದೆ. ಐ ಥಿಂಕ್ ದಟ್ ಇಸ್
ನಾನು ಇನ್ನೂ ಕಲಿತಾ ಇದ್ದೀನಿ ಸರ್. ಐ ಆಮ್ ಆಲ್ಸೋ ಸ್ಟಿಲ್ ಲರ್ನಿಂಗ್.
ಹೊಸ ಆಕ್ಟ್ ಆದ್ರಿಂದ ಸ್ವಲ್ಪ ಚೇಂಜಸ್ ಇರೋದ್ರಿಂದ ಕಲಿತಾ ಇದ್ದೀರಾ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಮ್ಗೆ ಕಲಿಯೋದಿತ್ತು ಸರ್ ನಮ್ಮ ಕೋರ್ಟ್ಗಳಲ್ಲಿ. ಅಂಡ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾವ್ ಒಂದ್ಸತಿ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಮೇಲೆ ಒಂದ್ಸತಿ ಮಾಡಿಸ್ಬೇಕು ನಮ್ ಕೈಲಿ. ಯಾಕಂದ್ರೆ ತಾವು ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಆಗಿರ್ತೀರಿ. ಹಾಗಾಗಿ ನಮ್ಮ ಹುಡುಗರಿಗೂ ಡೆಫಿಷಿಯನ್ಸಿ ಆಫ್ ಸರ್ವಿಸ್.
Judicial member ಅಲ್ಲ, I was the president.
Sorry,
I was the president, not judicial member.
Sorry, sir. President at Shimoga, commission. ನಮ್ಮ ಹುಡುಗರಿಗೂ ಅಥವಾ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ಸ್ ಬ್ರದರ್ಸ್ ಅಂಡ್ ಸಿಸ್ಟರ್ಸ್ ಗೆ ಈ ಅನ್ಫೇರ್ ಟ್ರೇಡ್ ಪ್ರಾಕ್ಟೀಸಸ್, ಡೆಫಿಷಿಯನ್ಸಿ ಆಫ್ ಸರ್ವಿಸ್.
ಶಿವಮೊಗ್ಗ as well as
ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಐ ರಿಮೆಂಬರ್ 4th 3rd ಅಲ್ಲಿ ಇತ್ತು. ಇದೆ ನಮ್ಮ ಶಾಂತಿನಗರದಲ್ಲಿ. ಎಸ್ ಸರ್.
ಥರ್ಡ್ ಎಡಿಷನ್ ಇರಬೇಕು.
Correct. With that note, sir, we will end today's session. We are so thankful on behalf of Academy Association, on behalf of the participants and my personal behalf, sir. We are so thankful to you, sir, for this extremely enriching session. Thank you once again, sir.
Thank you very much for providing me this opportunity. And once again, thanks to Advocates Association Bangalore and Advocates Academy Bangalore, and also to Mr. Trivikram sir. Thank you very much. All the very best.
Yes, thank you so much. Thank you all participants. With this, we will be winding up today's session. Good night.
Lagout agboda sir?
Yes,
anything
sir.
Else to talk?
Please, sir. Please.
ಏನಾದರೂ ಹೇಳೋದಿದೆಯಾ?
ನೇನು ಇಲ್ಲ sir. Thank you so much.
Okay, sir. So kind of you. Thank you very much.